tort liability for physical and economic harms. The learning outcomes include: we will evaluate how businesses are responsible when what they do causes harm. We will look at negligence policies and how they apply to managers and technology, as well as dealing with big data and healthcare. We will explain strict products liability. We will consider issues that are concerning to those who work in technology-related fields, public administration, healthcare. And we'll review practices that might be determined to cause some sort of damages or harm over the internet. Let's do a couple of definitions before we start. First, we look at what a tort really is. It's an unwanted intrusion on a protected personal right that causes someone harm. It can be physical harm, it can cost you money, or it could be psychological injury. If you are negligent, you may be liable for the damages that would be awarded in a tort case. To be negligent is when you are less careful than a reasonable person should be, and as a result of your negligence, harm occurs. If you remember the reasonable person standard, that's who would determine if you were negligent and if harm had occurred. Just a couple of quick, kind of funny cartoons you can take a look at. You can go through and look at tort liability, who's at fault, the type of injury, the type of damages given, and excuses that may be provided to try to lessen your role in the tort that occurred. And I'll let you look through that chart. The Restatement of Torts is what would apply in a situation like this. When you evaluate negligence, you look at what is the proper standard of care that was required under the circumstances. If you think about what we talked about, where a parent has a much higher fiduciary responsibility to a child than a random person walking down the street. So you have to determine what standard of care. A doctor has a different standard of care than I would if they see a person in need. Then you have to determine whether the conduct that occurred was negligence. There are 3 additional aspects that are evaluated. There must be some injury as a result of the negligence. The harm that occurred must make the person responsible for the harm, and there must have been a proximate cause that's determined to be the person you're trying to receive damages from. And there must be no defenses that would limit the amount of, or the liability that you have regarding the tort. I would encourage you at this point to take a look at the 5 elements of negligence on this video. When we evaluate causation issues in negligence, first we look and say the injury would not have occurred if the negligent act had not precipitated it. If there's more than one person involved, I may sue some of the people involved, all of them, or only one. Sometimes you select the person who has the deepest pockets. RIAA tried that, trying to go after the Napster and the internet service providers and so forth, and were unsuccessful. They then had to go after the individuals. And most normal, everyday, average individuals do not have a lot of money from whom you can then recover damages. You can look at joint liability or several liability. So perhaps I was negligent, but my negligence only caused a small part of the harm. Someone else was also responsible for some of the harm that occurred. And there are limits to the amount of liability that someone may have or that an organization may have based on some state laws. When you're looking at proximate cause and who's responsible for the negligence, it has to be reasonably foreseeable harm. Again, our reasonable person comes into play and has to evaluate that. It also has to be reasonably foreseeable that your negligence would have caused some harm. It can't be so far down the path that you had no way to know that what you did at one end would cause someone way away from you to harm themselves or to be harmed. I would encourage you to take a look at this tort law tutorial on proximate cause and intervening forces. Some defenses that you might use to the amount of liability you have for negligence. Well, the person being sued will usually say, it wasn't just my fault, it was the defendant's fault as well. They contributed to it, so I should not be liable for the entire amount. In that case, comparative fault would be assessed with each person or organization that has a part in the harm that occurred might have to pay a certain percentage based on their contribution to the harm, to the negligence that caused the harm. Here we look at Olecna versus Daytona Discount Pharmacy, and this is a recent case in 2015. The trial court first looked at this, and it was a fatal drug overdose. This person was prescribed anti-anxiety and painkiller medication from his doctor. He repeatedly re-prescribed the drugs before his prescription was finished. It was alleged that the pharmacy had a duty to not dispense prescriptions that were unreasonable on their face. The pharmacy rebutted it, saying, I only have to properly fill valid and lawful prescriptions that they gave me. And the trial court agreed. However, on appeal, the court evaluated whether the pharmacy owed a legal duty that would support negligence on their part. They determined that a pharmacist's duty of care in filling prescriptions can't simply be, I followed the rules. Robotic compliance, they called it. These prescriptions were filled too close together with no questions. They were unreasonable on their face. They said the trial court had made a mistake and that they had never decided if the pharmacy was negligent. In this case, they were. Next, we look at Vuono versus New York Blood Center. And in this case, Mr. Vuono was hospitalized for heart surgery. He received a blood transfusion, and it was contaminated. As a result of that, he became sick, and he was unable to complete his heart surgery. They determined that the vial of blood that was contaminated had been processed by New York Blood Center, so they brought suit against them. In this scenario, the Blood Center followed all standard operating procedures for the industry. It was determined that the glass vial that was manufactured by another organization, Wheaton, had a flaw in it. If the vial was inspected, it was visually identifiable. You could see it, but you had to look at each one. the crack in the vial is what caused the blood fusion to be contaminated. The blood center, however, said we should receive summary judgment because we weren't negligent. We did what everyone else in the industry does. The decision was the blood center had a higher standard of care than a reasonable person, or they called an ordinarily prudent person. And the standard of care may be higher than the guidelines used by everyone else in the industry. So perhaps the practice of the entire industry is unreasonable. Just because they followed everyone else's guidelines does not mean that they were not negligent in this case. Perhaps they should have inspected the glass vials. The standard of care in this case is very high since a person's life may be in the balance. The request for summary judgment was denied. So let's look, we've talked about this reasonable person a number of times. Let's look a little more closely at them. Someone who behaves as others do when faced with the same situation. They comply with laws. That's not everything, though. You may give consideration to economic principles. Did they profit? Did they make money and then not give you the care that they should have? A reasonable person may be an expert. So if it's an engineering problem, it may be an engineer. Maybe reasonable engineers need to evaluate. Or if it's a technology problem, perhaps reasonable IT experts should evaluate it. I encourage you to take a look at the reasonable person test video given here. Now we turn to strict products liability. And with strict products liability, the law says that the seller is liable for any harm resulting from a product they sold that was defective and that was unreasonably dangerous to the users. Unreasonably dangerous was something more than harm was required to see if a product was defective. There had to be something besides just harm to the person. It does not confine the liability simply to the person who sold you the product, but perhaps all the way down the supply chain to the manufacturer of the glass vial, for instance. Anybody who receives an injury from the defect can sue any seller within the entire distribution chain, whether or not you even dealt directly with the person in the chain, the manufacturer. So you can see the supply chain and where you're allowed to sue anyone in that line. Here we look at a couple of examples, and I have the Apple iPod and McDonald's hot coffee case that you've probably all heard of. Let's look at the Apple iPod first. Well, guess what? It might cause hearing damage if you play the volume too loud or too long. Certainly seems like an obvious danger. Apple, however, did go an extra step and add warning about the dangers. They also added software that allows users to set lower minimum volume levels if they choose to do so. So even though it appears obvious, they put in additional safeguards to try to make sure the user would not harm themselves. So they lessened the risk from injury. The McDonald's hot coffee case is one that's often cited as when people go too far. But here you look at the gravity, the risk that was posed by the coffee. Was the warning that hot coffee may be hot, was it made clear enough to the consumer? Was it put in bold letters so they could see it? Who is going to be drinking the coffee? the courts have generally ruled that there is no reason to add a warning that's intuitive and obvious. The McDonald's coffee case is often cited again as one that is silly. I do encourage you to take a look at the video here on the McDonald's hot coffee case. The woman who sued was an elderly woman who had never sued anyone in her life. She had on knit track pants, put the coffee between her legs to put some cream and sugar in it. Her son was driving, had pulled over for her to do so. When the coffee spilled, it gave her third-degree burns. It turns out that McDonald's hot coffee was hotter than industry standards by a significant amount. So they and she asked them, will you please pay for my emergency room bills of, I think it was around $20,000, and they did not agree to do that. So in that case, they probably wish they had, because there was a judgment with damages. But I'll let you look at the video and make your own judgments. If we look at strict products liability and apply it to technology, strict products liability is for products. So the question becomes, is the development of a website or an app, is that a service or is it an actual product? If it is a service, which is with the way that technology companies would like it to be viewed, then it is not subject to strict products liability. However, the more standardized the product is, the more it becomes a product. So Microsoft Office, which is standardized and sold to millions and millions of customers a year, is likely considered a product. Where, as opposed to an app that may have only a handful of downloads, it may not be considered a product, but instead a service. If strict liability principles are followed, then the person doing the development could be liable even if they follow all the standards of the industry. Think back to Vuono Blood Company, which followed all the best practices of the industry but still was liable. Developers might be responsible anytime whatever they develop, their programs, their apps, their websites, cause unexpected harms. A couple of examples of technology failures follow. One that's really interesting is an older one, Trespass 25, and it was a machine to deliver radiation to cancer patients, developed in the 80s, overseen by the Canadian version of the Food and Drug Administration. There were 6 patients who received massive overdoses of radiation. One of them, in fact, jumped up, and he had been receiving radiation therapy. He jumped up and said, "You're giving me too much. I know how it's supposed to feel." A later investigation showed that they did not do software testing at a detailed enough level to determine what was going on. In fact, after the first or second incident, they reported it, the hospital did. The developers came out and checked it, as did the Canadian authorities, and found nothing wrong. They could not replicate the error. It turns out that you were pressing P to go to the next page, and if you pressed it multiple times, like the operators were prone to do, then it would deliver a much higher dose of radiation, like 1,000 times higher. So these people were severely injured as a result of a software glitch. Obviously, when you have technology that impacts human life, you have to take extra care. Standard testing won't get it. I encourage you to take a look at the 2 videos, one on the Trespass 25 incident and one on other software disasters that have caused harm to people. So we know that our technology is going to fail. We have to make sure that we have a plan in place when there's a breach, when data is retrieved, when the software does not protect as we thought it should. And the reason you need to have a plan in place is because the per person cost of a breach, as you can see, can be substantial. Say you lose 1,000 records. In healthcare, that would be $316 per record, regardless of your level of negligence. So could you afford such a loss as that? In here they should talk about the healthcare industry, where 1.6 million patients and employees were affected by a breach. The security wasn't strong enough. They lost 3 unencrypted backup tapes during a building remodeling that had billing and payroll information on it. So that was a huge loss. In healthcare in particular, the cost can be substantial. So you've got to make sure the software you have is properly designed and won't cause any harm to others. Part of that is having a good security plan and a good response when there is a security breach. Repetitive motion injuries, you think carpal tunnel is one of these, because of technology can cause a significant number of sick days. One thing that can be done is to develop ergonomic standards, put the components in the right place. Companies that do implement these accommodations usually receive a good bit of money back on their insurance rates. Trespass by electronic robots, something you might not think about, but is based on the law of trespass to a chattel, which applied to cattle many years ago, but is interfering with someone else's interest in property. Even if your cow came over and ate some of my grass and it was an insignificant part, it was still mine. So software robots the law has been applied to the trespass to chattel with software robots that automatically search, copy, and retrieve information. If they do it without permission or where explicitly prohibited, you can be negligent and may be liable for damages, because it does consume some of the space, some of the bandwidth available to the organization or the technology or whatever it might be. Just like that grass is not available for my cows to eat, those resources, although small, are not available to me, to the owners. eBay and Ticketmaster have both brought suits on these principles because they explicitly prohibit electronic robots from coming out and go scouring through their products. Intel did try to bring a trespass claim against an employee who got mad when he left and sent out an email that was very critical of management and sent it out to all of Intel's employees over their computer system. It was one email, it was very small, but the content was not what the Intel managers would have liked to have seen out there, and it may have caused some people to form a negative opinion about the Intel managers. However, the court said these damages aren't relevant to trespass because you have to have a harm or have to have a system that's not available to you. And in this case, Intel didn't demonstrate any likelihood that what that employee did with the email would be done by others. So it's unlikely to occur again. Anti-spam laws have also been passed. The U.S. laws are not nearly as stringent as the EU laws. With the U.S., you have to tell to and from, you have to be able to opt out. Canada has a little bit more that private right of action as of 2017, but for whichever one, you have to clearly identify the sender and must give an unsubscribe mechanism. The EU uses an opt-in process while the US uses an opt-out process. With the EU, rather than saying, would you like to receive all our newsletters, and it's automatically checked yes, the EU requires that the user initiate that contact and opt in. So their anti-spam laws are usually a little more restrictive, give the users more privacy. A couple of federal laws on spam. There's not much. We all receive spam. Not a whole lot you can do. But a couple of laws that do apply to spam. With the Computer Fraud and Abuse Act, it does make it a crime to access or damage any computer used for government purposes or by financial institutions. So it's very limited. The Patriot Act does extend the protection for you can't introduce a virus that causes damage to any organization, not just government owned. You may be prosecuted, you may be sent to prison. There have been a couple of notable judgments against spammers. Facebook was awarded $711 million when you had people accessing the Facebook websites using phishing and then sending out spam. The main spammer here was called Spamford, and he and his friends were permanently barred from creating a Facebook account or accessing Facebook and ordered to pay damages. MySpace also won a suit against someone called the Spam King and was awarded $6 million. So you can have large judgments if you harm another's bandwidth or their technology without permission. Malicious code can obviously lead to cyber terrorism incidents, even where you shut down the financial system of a country, or a government tries to access another government's information. My guess is it happens even more frequently than we know, but you can have a virus, a Trojan horse, whatever, that can really damage a system rather than being simply a fun thing happens. I encourage you to take a look at this where a hacker claims to have taken over a flight's engine controls. The FBI is not convinced that this person did take over the controls, but since he posted on Twitter, they did talk to him when he landed. Another area where you might see potential issues with causing harm through others interfering are cars. Cars are becoming very smart. They have Wi-Fi enabled. They drive themselves. There are a lot of potential liability that can happen with computers malfunctioning because it can result in the loss of life. Now, Google's car, which had traveled many, many millions of miles, had an accident not long ago, and a bus ran into it because the car assumed that the bus would yield. The driver in the car, there was a driver there, said he would have done the same thing. Nobody was injured. It was very slow rate of speed, and that was the first accident it had had. But we'll have to see how secure they are, because if someone is able to break into your car while you're driving and interfere with your ability to control the car, obviously that could be fatal. So I encourage you to take a look at these two videos on things that might happen with smart cars. Summing up this chapter, as a manager, you may be liable for causing physical and economic damage, even if you follow industry guidelines, even if you think it's a service and not a product. You should avoid negligence, so you should make sure you follow stringent standards that a reasonably prudent person would follow in your industry. Even so, strict products liability may cause you to be negligent even if you did nothing wrong in terms of industry standard. Obviously, making sure that technology is secure, particularly when it can harm someone, like the Theris 25 or the driverless cars, is of prime importance. It cannot be a general standard. It has to be loss of life can occur, and I must have higher standards of care.